going to be the story that we're going to be probably covering time and time again over the next 2 years. The Chauvin, let's start with the easier aspect of this. Chauvin brought up on federal charges, civil rights, as the other three lawyers. No big surprise. It's just your point in this is that the double jeopardy system in America is broken when these same individuals can be charged under different sovereigns for crimes resulting from the same crime for which, at the very least, one of them has already been convicted.
Yeah, and my argument is they're not really different sovereigns. That's a legal fiction. The United States government is called the United States government. That means it's not a separate sovereign, in my view. It's a state-created entity to regulate each other. It's a compact between the states. And so the idea that a state government is a completely different sovereign from the federal government, as if it's France versus Belgium, just doesn't make sense to me. And so I find that fundamentally problematic. I don't think they ever should have adopted that principle. And if you continue to adopt that principle, you could subject people to 20 consecutive prosecutions and successive prosecutions, because you could keep going on, and you create more different divisions of a government and call it a different sovereign with overlapping authority. The point of a sovereign is that you don't have overlapping authority, right? This sovereign has this territory. This sovereign has a different territory. They don't both govern the same territory. That if you have this, in fact, there used to be a concept called, it still exists, called territorial jurisdiction. And there's also in personam jurisdiction, and jurisdiction because of you as an individual. And so here we have the state citizenship and United States citizenship are co-equal, because you're a citizen of the state, you're a citizen of the United States in general. And then the territory is the same. So the principles behind dual sovereignty don't apply in this context, in my view. When you have the same territory and same citizenship. So that's my problem. But that ship has sailed. The way I consider it is this is the judges let them get away with it. Doesn't mean the law lets them get away with it. It means the way the judges interpret the law let them get away with it. From 1895 to 1950, for over half a century, our judges in the South, state and federal, came up with every excuse in the world why not only most African Americans, but also many poor whites couldn't participate in their own governance. So, that's what the law, they said the law was something that it wasn't. They lied about the law. And in my view, that's what's happening in the double jeopardy, dual sovereignty concept, because it just doesn't apply. But either way, that ship has sailed functionally. But a lot of people are still shocked. You'll find random people that'll be like, doesn't double jeopardy prohibit this? Oh, no, you didn't know our U.S. Supreme Court carved out a special exception that pretends that state governments are totally foreign to the federal government under double jeopardy principles and precepts. So, but in terms of the substance of the charges, the Department of Justice does have a policy not to do this in general. So they're only supposed to pursue it in unique circumstances, and they're not supposed to pursue it when the state convicts. The reason why their political excuse for this from the get-go was what happens when your local state government is corrupt and can't convict. Here they convicted Chauvin, and then they're still going to prosecute him again. It looks punitive. It's problematic from a political perspective, in my view. But putting that aside, go ahead.
No, I was going to say the burden. The burden of proof, or the evidentiary burden. I'm thinking more for the other three cops on the civil rights violations. Is it going to be easier to prove than the charges as they currently stand against the other three officers? And so, to some extent, it's not the second kick at the can, but it's a double kick at the can, and to try to get them on something that has maybe a lesser evidentiary burden to obtain a conviction.
Really, ultimately, it comes down to a lot of the same things. So the biggest difference is causation. They don't necessarily have to prove, it depends on how they approach the case, but they don't necessarily have to prove that it caused his death, that they can say something else. Usually that part relates to sentencing, but there's constitutional arguments about whether they may have to prove that at trial if they want the death penalty, for example, which appears what they're thinking about. Ironic from the Biden administration that claims to be opposed to the death penalty. The conflict within the Democratic Party is extraordinary right now in criminal justice, because the left says we shouldn't have this incarceral system, punitive-oriented criminal justice system at all. We should defund police. We should release everybody from prisons. And on an empirical basis, they have some good arguments that our incarceral system doesn't really work, at least not in the way it's sold to the American public is working, that it intends to harden criminals and create a criminal class, not deter it, especially as it relates to juveniles. But on the other hand, They want to weaponize the prosecutorial process to have the harshest punitive sentences for their political opponents or for politicized cases. And they can't seem to make up their mind. Well, are they Stalin, Soviet Stasi-style prosecutors, or do they really believe in opening up the prison jails? You can't have both of these principles put together at the same time. So we'll see how they work this out. But it's probably one of the most overt dual successive prosecutions in American history. They did this in Rodney King, but that was because they got acquitted in the state trial, not convicted. Now, the elements are a little bit, so there might be different elements on causation. Otherwise, everything else is almost the same. In fact, if anything, it can be tougher in certain contexts in the federal context because they have to prove willfulness. And that's a word that shows up a lot. And its interpretation can vary in the federal criminal justice process. But generally what it means is you have to know what you're doing is illegal. In the police officer context, it means you have to know what you're doing. In the criminal tax context, you have to know it actually violates the law. In other contexts, you have to know it violates the thing that the law prohibits. So in this context, you have to know not only that you exercised unreasonable force, but that you knew you were exercising unreasonable force. And so it was unclear in the Chauvin trial. Those instructions were vague in the Chauvin trial. They'll be more clear in the federal trial. So they don't necessarily have to prove certain aspects of causation or intent to cause serious risk to human life, unlike the state charges in part, depending on how you interpret felony murder in the Minnesota criminal system. But you do have to clearly show they knew they were violating reasonable force rules, that this was unreasonable force. And in the other officers, they had to have the aiding and abetting part is pretty comparable in the state and federal system. But to the degree the state instructions are vague, the federal system is clear. They have to know that this was unreasonable force. Now, they have an interesting interpretation. They're alleging deliberate indifference, which to show they have three different criminal counts. Some only apply. One only applies to Chauvin. Actually, two only apply to Chauvin, I think. No, one applies to Chauvin, two applies to both. They've also brought up Chauvin on separate charges for a prior incident that don't involve the other officers. But involving the other officers, it's aiding and abetting the exercise of deliberate, the excessive force. And they have a theory of aiding and abetting deliberate indifference or doing deliberate indifference, which is, they have an interesting interpretation here. And again, they contradict each other in terms of the state's position on different issues across this area of law. They're saying that it's deliberate indifference not to have given George Floyd medical aid. I've dealt with a lot of other cases where they say there's no duty to provide such aid. So, the government, including the state of Minnesota, including the feds. So it's a fascinating contradiction. Also, it's another, if you compare this case, they're prosecuting the other officers, including officers who said maybe we should flip them over, who just took their supervisor's guidance, while they're refusing to even name or further charge the officer who did the summary execution in the Ashley Babbitt case. This shows how overtly political the Biden Justice Department is.
Well, okay, we'll see. Do they get tried together, all four of them, or are they going to have separate trials on the federal charges?
The government wants to try all of the federal charges together. They will likely move for a severance. Two other differences are, it's whoever the federal judge is, and the federal judge may not be a Democratic ally, like you can pretty much guarantee a Hennepin County state court judge would be. Even though I thought Cahill went out of his way to be good, he still was aligned with the Democratic Party. No guarantee that will happen with the federal district court in Minnesota. You also have the Eighth Circuit Court of Appeals that would be involved in the case. That's a federal court of appeals that now, while it always could have reviewed Chauvin's case in the state proceedings through a habeas petition, now it's guaranteed to review this case because some of the same issues will be implicated as in the state court proceedings, not the state law definitions, but the other aspects, and a different jury pool. This will not just be Hennepin County. So, that's why typically if you file a state civil rights case, in most jurisdictions, the city will remove the case to federal court, which is always ironic, right? The city of Milwaukee doesn't want Milwaukee City jurors on a civil rights case involving Milwaukee City misconduct. They want those suburbanites brought in, the people who fled the city in the first place. So who will be overly deferential to the police. And so they'll have a very different jury pool potentially. And then with all the controversy, which this might be a good bridge to, with what happened with the juror, I think usually the federal system is atrocious in jury selection, but there'll be major pressure on the federal system to have a different kind of jury selection process, issues of sequestration, and issues of how deep to go into jury selection, and venue issues that will all be pertinent because of what happened in the state proceedings.
All right, and JP says the courts have become purely political and are prosecuting their political rivals in the name of unity. We are one step closer to becoming the United Communist States of America. And we discussed this with the George Samueli last sidebar. You know, talking about the Navalny trial in Russia being a farce of a trial. I have no doubt that people overseas, Eastern Europe, or in other countries are looking at the American system or the American prosecutorial system, maybe to a lesser degree Canadian laws, and saying probably the same things about us from over there. But let's get into the bigger controversy of the Chauvin case. The jury member who has now been outed, although it was only a matter of time, especially given how vocal and public he made himself. This is Brandon Mitchell, one of the jury members who immediately upon conviction, before sentencing, basically the day after the conviction, started doing the media rounds. A lot of people are hypothesizing that, I don't know if this individual gets paid for these media appearances, but there's hypothesizing that he is setting himself up for a lucrative book deal. We've seen it happen now from Amy Coney to Hunter Biden. Some people get book deals, other people get 6 months in the slammer. But he started doing the rounds, and in doing the rounds, he identified himself. He got his name out there, and very shortly, a very incriminating photograph, which was pre-trial in August of 2020, of this jury member at a Washington rally, which was for Martin Luther King Jr., but was a police brutality rally, and he was wearing a shirt. For anybody who has not yet seen the shirt, it said, get your knee off our neck. And it was a BLM shirt, and his was a BLM hat. And it became known now that this individual had attended a police brutality rally and seemingly had very favorable positions on BLM. I don't think anyone wears that prominent gear without supporting the message and the organization. The jury questionnaire, which we covered in a previous vlog, had specific questions on this. One of which was, other than protests in Minneapolis in support of George Floyd, have you attended any other police-related or police brutality rallies? To which he apparently responded, no. So that's the factual background now. It is not a hyperbolic or an exaggeration to say this is objectively a tainted juror, to the point where it makes Runaway Jury, the movie, look less absurd. The question is now, what's going to be the outcome and what's going to be the consequences for him? Nelson made a motion for a new trial. Actually, I want to get into that, Robert. Nate Brody and someone on his channel during a live said something that was missing from Nelson's motion for a new trial were specific allegations on jury misconduct, on the jurors' misconduct, which I didn't pick up on. You know, he alleged it in the beginning, but it wasn't enumerated in the body. Is that going to be a fatal deficiency? Can Nelson amend to add a specific allegation to that? How does that work?
He hasn't actually brought the motion. He's brought a notice that he's going to be bringing motions. So what it is within a certain time frame, you have to apprise the court of what issues you're going to raise. You don't have to provide the memorandum or the evidence for it at that stage, is my understanding in Minnesota. Some courts, they require that, but that's pretty uncommon because usually you need time if it's a post-trial related issue. So, and in Minnesota, they have an evidentiary hearing process that as to the juror. So what they will likely request is that evidentiary hearing be held, and Mitchell will have to come in and testify about a range of issues. And I suspect the judge will authorize that to occur. So that's not necessary procedurally, because it wasn't the substance of the motion he really was bringing. It was a notice of, here's the motions we will be bringing, and here's the grounds. And he had multiple grounds beyond just the jury misconduct issue. And it mostly followed the issues we talked about as the grounds for either a new trial or an appeal. And that included a range of issues that happened at trial. The big ones being the venue determination, then the jury sequestration decision, the failure to instruct them not to review on social media, the refusal to allow a cross-examination of the witness who was taking the fifth, the drug dealer that was in Floyd's car. So the jury's never heard about that. Evidence concerning cumulation, because he really allowed cumulative evidence to happen. In other words, you're supposed to have one expert for a topic, not four. I think the prosecutors may have had 8 when you include some other people they had testify on their behalf as experts. That issue, allowing the prosecutors to lead the witnesses in certain contexts. Well, the biggest one I did not know about was the failure to inquire of the jury after the Maxine Waters statements were made, and failure to sequester. But the big one I did not know about is I didn't know that all those sidebars the judge was keeping no transcript of. That's a bit of a problem. You're really not supposed to do that. I get why, because he didn't want things published, but you could seal that. So to not do that leaves open doors to what really happened on a bunch of evidentiary rulings.
Are the sidebars, despite not having a transcript, are they recorded, or are they totally?
They were not. Apparently, that's what's alleged. It's that there's a bunch of sidebars with no notes, no recording, no transcription. That'd be a problem, potentially. Now, they find excuses to get around that, but they really don't like that because of the problems that it can raise. The defense lawyer can say, "Hey, I actually raised this objection," but I always tell lawyers, because there's some judges that will do that sort of thing. Always make sure you have an offer of proof on the record at the end of the day or anything else. Hey, I raised this, so we'll see. But he has unusually strong grounds, both for a new trial motion and for an appeal. And the question is whether any court will have the political will for it. I do believe that the federal prosecution gives the state courts a lot more leeway, because now they can let Chauvin walk and uphold the system and clarify criminal law and protect venue rights without Chauvin getting to walk, because he's already going to face federal prosecution. So to some degree, the feds rushing in the way they are is actually giving the state courts an excuse, political cover, to do what I consider the right thing legally. Now, in terms of and his main argument is the juror misconduct is evidence of why the failure to sequester, why the failure to transfer venue, why the failure to expand the jury pool to be outside of Hennepin County, why the failure to inquire after the Maxine Waters statements are all consequential. He also has the jury instructions and raising questions about the law, of course, in his appeal. But so transitioning into the juror, what I think happened is this guy gave off the vibes of being an activist. I don't think he's driven by money or notoriety. And he made some statements that sounded like that right out of the gate. One, he confirmed what we said, that this was not a conscientious jury, that they probably would have convicted even quicker if they could have, and that there was one holdout. And they would have convicted in 10 minutes. That gives you how a sign of how thorough this jury was. An embarrassment to the rule of law. Those 11 jurors who sat on the jury and rushed to a conviction should be embarrassed and ashamed of their failure to uphold their constitutional duties. They decided to be the mob. They're no better than a lynch mob, because that's what they did. And
what the juror said, it does lead you to question what the juror, the activist juror, who's a BLM activist juror, might have said to the one other juror who seemed to be the lone holdout. And when you're talking about jury intimidation, and it was alleged in Nelson's motion, you can imagine if it's not overt, at the very least implicit jury intimidation from any juror who might, they may not know that this particular juror is a BLM activist or supporter, but they probably do. And you can imagine what type of intimidation that is having one of the very people who are out on the street violently protesting in the jury room. And I can only imagine what type of jury intimidation that would create for anybody who was, in any way thinking of defying the will of the others. I can't imagine anything more intimidating than that, actually.
What we talked about is what the press and the prosecutors were pushing in this case was to weaponize mob justice inside the jury room, to make 12 Angry Men a documentary, not a film. And that's, in my view, what this guy basically said. Because what he also said was, he said things that sounded an awful lot like, I was an activist. I lied to get on the jury. I learned how to mask my emotions. I learned how to stay away from certain answers. I learned how to frame things in a certain way. To give you an example, this was the juror that I thought could be an acquittal juror based on what the media reports of what he said. So this guy was deliberately, he was the one who said he didn't think Chauvin had intent. He was lying across the board. He was lying to get on the jury, and he was encouraging other people to do so. Afterwards, he was saying, this is how you do it, folks. This is how you sneak onto the jury. This is how you tie that lynching rope well. And that's what he did. And then he kept lying about the rally, lied about how often he wore the T-shirt, lied about how much he remembered about it.
Yeah, he said it wasn't a what did he suggest that the rally was for? Voting rights, I believe.
Martin Luther King. He was just there to honor Martin Luther King. It had nothing to do with George Floyd's family being at the rally and speaking. That's relevant. And see, to give you an example, NBC was so embarrassing, they didn't even cover this. NBC News initially. ABC was even worse. They had a lawyer on from the Johnny Cochran law firm, which I'll give Johnny credit. He monetized his name all across the country. Everybody got to stick Cochran. You pay him some money, you get to stick, he had nothing to do with that law firm. For a certain amount of money, you could pretend to be part of Johnny Cochran's law firm effectively. I mean, that's clear when Johnny's dead and it's still the Cochran law firm. But this lawyer was on there, and she tried to say with a straight face, ABC News had this person on with a straight face saying, I don't see any sign of bias in that T-shirt. Get your knee off our necks. I mean, that's like saying, okay, yeah, we saw the guy in a Klan outfit and we have a photo of it, but he didn't have any bias concerning a black defendant. This is a crock.
No, it's preposterous to the point where it requires willful blindness from an audience to buy into it. So it's objective. The only question now is, what do you do with this particular fact? Nelson's made his motion. Incidentally, one question about the motion before I forget. Maurice Hall, he alleged that the confrontation provision of the Constitution was violated. The provision I read in the video was just, the right to a speedy trial, et cetera, a jury of your peers. The confrontation clause, I don't know what that means exactly, but I imagine it means the ability or the right to confront even a witness that is going to take the fifth, right? Is that what it means? Like, yeah, I can bring him up, even if all he does is say, I plead the fifth, he wants the jury to see the person pleading the fifth.
Correct. And you have a right to confront your accusers, which has been broadly interpreted to mean a right to confront any witness, a right to subpoena a witness, a right to ask questions and cross-examine the witness. It also, for example, the confrontation clause often limits the effect of the hearsay rule. So the hearsay rule has a constitutional component in these cases, in criminal cases. So that's what he was referencing, and that's.
So I was going to say, so the judge Cahill he basically said, we're not even going to compel this guy to appear as per the subpoena because all he's going to do is plead the fifth, so it's useless. Chauvin and Nelson are going to say, we want him up here. We want the jury to see this guy plead the fifth, if nothing else. Just from a practical point of view, when does a judge end an examination of a witness who's only pleading the fifth? Do they let it go on for 20 minutes, an hour, or 30 seconds?
I mean, usually just it depends. But it's where the Fifth Amendment right of the individual conflicts with the confrontation right. But generally, there is no violation of the Fifth Amendment right because the individual can assert it. And unlike involving the defendant, you can make negative inferences about asserting the fifth when that person's not the defendant. In a criminal case, you can also make negative inferences about the Fifth Amendment in a civil case. So so that's why it's usually permitted or should be, I should say, permitted. Courts often go back and forth on this. Famously, Mark Furman, the lead investigative officer who magically found all the evidence in the O.J. Simpson case, also took the fifth. That's who people are relying upon for believing the government's narrative about the O.J. Simpson case. But that will be for another later show.
All right. And now the question is, what happens? There's going to be a motion for a new trial. Cahill is going to hear it. Is there is there a time frame roughly, or does it take some time because they need to get the transcript of the trial?
Well, not only do they need a transcript of the trial, there'll probably be a juror misconduct hearing. And here's the interesting thing. There's only one juror. There's an alternate juror came out and talked, but only one regular juror, actual voting juror who has talked, and he ended up being corrupt. So what does that tell you about the possibility of 10 of the other 11? Well, what happened with them? So we still don't know. Remember, he's delayed that for 6 months, the publication of that. And there is one other addendum we should get into that Nick Requeta asked about, which is whether the defense was thorough here and whether that will be a pretext of the prosecution, whether this was knowable information prior to his selection. But putting that aside, The public doesn't know about the other ones, and who knows what they'll find, because you see the utility of crowdsourcing, and it's why I generally oppose anonymous jurors. I understand why they did it in this case, and there were good arguments in this case, but it's risky because you get a Roger Stone problem. So Roger Stone, Roger Stone, there was no justification. There was no risk to these jurors in D.C., in my view.
Purely, I would say, it's purely political. No real risk of any sort of outrage from anything. Abusive. Well, here's the bigger question that a lot of people are asking. The jury questionnaire was under oath, so technically, if Brandon Mitchell unequivocally lied on the questionnaire, in theory, he can be brought up on charges of perjury.
So two things about that. One is, I think that they filled out the juror questionnaire before he went to that rally. That may be the case. That's part one, depending on the timing, but that's my understanding of the timing. So he may not have lied in the questionnaire, though I wonder a bit, because who shows up at multiple rallies with that, or a rally, but multiple appearances with that kind of T-shirt? He smells of an activist who created a fake story. It's a literal, people should watch, great film, good book, The Runaway Jury. Now, the movie makes it all about guns. The book was better. The book was about big tobacco, more realistic, more understandable. The idea that gun companies get away with stuff is just a bunch of gibberish. But that part of the narrative change by Hollywood I was not a fan of. But the rest of the film was still a pretty good film. And the book is actually a very good book. John Grisham describes the reality. People think that kind of jury selection, featured on the TV shows and other things, are not what happens in sophisticated cases. That's what sophisticated jury consultants do. Maybe not. I mean, not necessarily a Gene Hackman degree, right, where he's spying on people's, but in some big corporate cases, big government cases, you can't put that past them at all. Go back and read about the Jimmy Hoffa case. The Jimmy Hoffa jury tampering case arose out of Chattanooga, Tennessee, my hometown, and they went after Bookie Turner, great police commissioner in my hometown, because he found the feds were spying on the Hoffa jury. How did they find out about that so-called jury tampering in that case? People should put one and one together. Maybe somebody else was spying on that jury. So but that's another story for another day. So I think in terms of, but the problem he has is the judge specifically, his first question to every juror was, remember your answers. Is there anything now about those answers that are true or untrue? His argument might be, well, when I filled them out, they were true. And you didn't make clear whether anything had changed in the interim, though the judge made those kind of comments. I think it would be tricky to prosecute him for overt perjury, even though I think he was being deliberately deceptive. And I think there's no chance in the state of Minnesota or Hennepin County is going to prosecute a juror for leading the lynch mob. And nor will the feds. The feds could, that could be a potential violation of civil rights acting under state law. Apparently they're looking at that for the Ahmaud Arbery case. I'm not sure how that's supposed to work, but because usually this is supposed to be only government agents, but in the juror context, you could be acting under color of state law as a sworn juror, or as a sworn prospective juror. So there might be some civil right, but nobody's going to look at him because of the politics of the situation.
But the ultimate irony is going to be that if there is a new trial declared, I suspect some people are going to blame this guy, and some people who are, the very entities that have been in the streets and protesting are going to blame this guy, and it's going to be infighting that's not going to be pretty. Because my prediction, for what it's worth, I'm a lowly Canadian schnook who does not practice criminal law. They have to order a new trial, and if they don't, I don't know. It either comes now or on appeal. But I think Kale is going to order the new trial, and I think he's going to pin it on Mitchell as the catalyst or the straw that broke the camel's back for the one thing that went too far that is just undeniable now. Maxine Waters is one thing. I think it's very easy to pin it on Brandon Mitchell. I think the judge is going to do it, and then I think there's going to be a heck of a lot of infighting.
I think that they need more. So I think it's going to depend on a very effective cross-examination of the juror at the hearing. They have a specific court case the hearing is named after. And I think ideally they would get more jurors to talk to them, to confirm more information, more evidence, because otherwise it's very, very tough. Give you an example in the Snipes case. 9 jurors were for not guilty across the board. 3 jurors had lied to get onto the jury. We tried to out them as best we could. Judge shut us down. And they admitted in the jury room that that's what they had done. And now different lawyers handled that part of the proceeding, and they didn't follow my advice on that. And I think if they had, they would have had a better chance. But the judge found all the excuses in the world why he couldn't set aside the jury verdict, even though 3 jurors admitted they lied to get on the jury in order to convict them of something. And that's the only reason why 3 misdemeanor convictions even happened, is because they held out for those 3 misdemeanor convictions. Acquittals of all the felony, fraud, conspiracy, and tax evasion charges, and half the misdemeanors, but conviction on 3. That was a fraudulently obtained verdict that the court was glad to rubber stamp because they look to cover up cases like this. So I don't think Cahill's that kind of judge, but generally speaking, given the political weight around this case, though again, Cahill now also has some immunity because the feds are prosecuting him anyway, along with the tax charges that are still pending against the guy, against Chauvin. In that context, he has more leeway, but I think he's going to want more compelling evidence. Now, in terms of what the defense lawyers should have done and whether that will be an excuse, generally speaking, if you have evidence before trial or before a verdict, and you don't raise it to the court and you only raise it after the fact, then you can be considered to have waived that right. But often that sort of doesn't always solve the problem from a prosecutorial perspective, because that raises issues of ineffective assistance of counsel if your lawyer's the one who made that choice. Now let's say you didn't know about it, but you should have known about it. In that context, that can also be grounds to excuse the misconduct that took place. And as to that, I don't think, well, here's what I think. I think a really good lawyer would have found it. But 95% of lawyers don't even look at jurors' social media. In the federal context, you usually never get the time. In a typical federal trial, like the reason we'll get into later, like comparing the Navalny case versus U.S. cases and so forth, the big difference is, the jury selection system in the United States. But in the United States, the federal criminal process has a much higher conviction rate than states in the 90s consistently. And my view is the main reason for that is states usually have much better jury selection than the feds do, because the feds usually give you 30 minutes to an hour to pick a jury from the time you meet them. You even get to know their name. You're supposed to look up social media in an hour. So that's part one. But in this case, they had plenty of time to research them. Now, they used to threaten lawyers that if they tried to research jurors' social media,
it would be unethical to interfere or influence a witness.
You're contacting
a jury member. Sorry.
Exactly. And so that ship has now sailed, in my view, with the Roger Stone case. Once the judge said, "Oh, it's your duty to do so," I'm going to be using that anytime anybody starts to raise a question. Now, I have for a dozen plus years used outside third-party vendors to get me every piece of information on a potential juror that's possible, and find every way conceivable to try to make sure the jury process is more thorough and expansive. But it's an uphill war in the federal court system, and not so much in the state courts.
It doesn't make sense that it wouldn't actually be required, not just potentially unethical and forbidden. It doesn't. Well, they're answering under oath. They're going to be assuming something of a quasi-public function. Mm-hmm. It doesn't make sense that you would not be able to vet in a meaningful sense the questionnaire and their statements under oath. So it's foreign to me, but it's foreign to me. I've been familiarized, through our live streams. It's a bizarre idea that you just take them at their word for it. You have 30 minutes to find out, maybe an hour, depending on if you're lucky. And if you find out something after the fact, well, too bad, so sad, it's too late.
Well, to give an example, in most federal cases, the lawyer doesn't get to ask a single question of the potential jury. Only the judge asks the questions. And the judge asks leading questions. You agree that you can be fair and neutral, right? You agree that you can set aside any possession you have and make it all those bogus questions that are utterly useless, that the only people that will answer honestly are the ones that would actually be good jurors. Bad jurors will say, "Oh, I can absolutely be fair and impartial," and all human beings believe this. The ones that are aware of their biases will be the best jurors, but because they'll admit their biases, they'll be excluded from the jury process. It's insane. So only in state courts usually do you get to ask a single question to the jury. And in federal courts, I've had judges threaten to put me in jail if I ask questions of the jury that they haven't pre-approved. I mean, that's how bad it is. The reason is this. They know that your average jury will be a pro-government jury. And consequently, their goal is to use the jury process to validate and vindicate the conviction, not because they want an actual truth-seeking, moral, justice-seeking jury. That's the last thing they want. They don't want any Ed Snowdens wandering around on that jury. They want jurors that will say yes. They want a jury like the Japanese system, where the Japanese '1 in the world in conviction rate, over 99% every single year. Why? It's because they're very deferential to authority by their culture. And they know that's a reflexive jury. So they know the less questions you get as a defense lawyer, the more likely you're going to have a pro-government jury sitting there. And so now, but in this case, it appeared he gave them broad range to ask questions, did a written questionnaire. They got news and information about the jurors months in advance. So I believe a good lawyer should have done deep research on this guy. But to give an example, this wasn't on his social media. Somebody probably didn't do the search because Facebook's tagging function is what uncovered this guy. This guy's uncle bought into, how Facebook tags and asks you to put, who's in this photo? And the uncle was like, my nephew's in this photo.
You don't need you don't need Secret Service. You don't need spies when you have social media and all of their tagging mechanisms. There's a reason for it, and there's a very, very big risk to it. This is one of them. Yeah, it was his uncle that posted it, tagged him, and it was discovered afterwards. But
by a bunch of social media independent detectives. That's why they do great work, and published and broadcast by, once it was confirmed, by Jack Posobiec. And so that kind of makes the defense lawyers look bad, but in the defense of defense lawyers, 95% of them don't even do anything with social media. To give you an example, this was before social media was really big. In the Snipes trial, we had like massive books because we were going to get the jury information late. We knew that. So I wanted every person who lived in the entire area and as much information on everybody. And, what people don't realize is these days with data, even without social media, you have 300, 400 pieces of information on most people. Every subscription you've ever made, every donation you've ever made, every place you've ever been, intel's out there. And so I remember we were going through them and we were picking to go do different jurors, and I was highlighting different facts that were key. The other defense lawyers, because there were other defendants in that case, were shocked. They're like, where does this come from? Gives you an idea of how abnormal this is to defense lawyers. Still is. And Snipes made the joke to one of the defense lawyers. He goes, wait till we see what we have on you, which is kind of ironic because that lawyer ended up, well, that's another story. pretending to be me and going to certain clubs. So people were saying, I heard Barnes was at this club. I was working the whole time, and it turned out this guy, because my name had been in the press, thought it would get him more attention from certain companions at those clubs. Let's put it that way. So all these rumors about me were spreading around. It had nothing to do with it.
Probably the ultimate plot twist. You were at those clubs, Robert.
My evil twin, Paul. But I was nowhere near any of those places. Man, that case was brutal. Only got stuff the night before. But that's abnormal. So it's hard to say that that's unethical or professional malpractice for him not to have found it when this whole thing is foreign to most defense lawyers. Now, I hope that defense lawyers learn from it and realize you need to have good pollsters. You need to have good focus groups. You need to have good mock trials. Now, I understand in some they don't have the resources, so I get that. But if you have any, and here's the other thing: defense lawyers spend all their money. I told on Eric Hunley's Unstructured podcast, unstructured.locals.com. You can find him there too. That in the process. Oh man, I just completely forgot where I was at.
Discovering on social media using proper pollsters and researchers.
Yes. Yeah, in terms of that, if I had a choice as a defendant, and let's say I only had $25,000, and I had a choice between hiring a lawyer for $25,000 and spending the whole $25,000 on a jury selection person, I'd spend it all on the jury selection person. That's going to make a bigger impact on your case than the entire trial. Trial is 90% theater, 10% persuasion. Most of the time, you're there in the theater to persuade the people to give arguments to the people that are already with you in the jury room. That's it. But if you don't have enough of them, it doesn't matter anything you do. But lawyers spend all their time where I'm going to cross-examine this person, and then I'll get the direct examination and the day-to-day drama, and then I'll get the jury instructions. And none of that matters 90% of the time. It's all about who your audience is. If you haven't won with that, you're not going to win the trial. So for ordinary people, think of it this way. Let's say if you're Trump and you're picking a jury. If you pick a bunch of Democrats, do you think they'll ever rule in favor of Trump? That's the way human beings are, even about cases they've never heard about before they walk in. And in this case, they'd all heard about it before they walked in.
Well, I mean, this was just, it was over the top in terms of what it was. The idea that it could have been discovered beforehand. I mean, to some extent, that's like saying, if I lie under oath, but you could have proven that I was lying, then it's your fault. I don't know how far that goes, but again, my experience is limited.
That's often what the government and the judges argue, by the way. They say, you should have figured out the government was lying to you. It's on you. It's amazing the excuses they'll go to. But I agree that Cahill should grant a new trial. I think they need to develop more evidence from more jurors and more evidence about this juror in order to do so. Now, my guess is this guy wasn't hiding that much. Yeah, he's appearing on podcasts before the trial started. He was appearing at the rally, allowing photographs to be posted on social media. Wasn't making sure those were removed beforehand. Hadn't really done a search of his own name with photo images beforehand. So I think all of that's going to raise some trouble for him. But I do think defense lawyers should learn you need much better jury selection. You need more involvement of pollsters and data professionals, because there's a wide range of data and information, because you don't want to be that lawyer that missed the glaring problem with one of your potential jurors.
Nelson will always have an excuse. He was the David versus the Goliath, didn't have the team, he was the one-man show. But I mean, and in a way, it might be better that it happens this way than before, because now you have a better argument. What would you do if you discovered a jury member was tainted in the process? You'd make a motion to disqualify a juror?
Oh, yeah, immediately. Okay. Yeah, in fact, you're obligated to do so, or you waive it.